This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
Welcome. Again, 2 Sundays in a row, I think, Gary. A Sunday early drop start on the week. This one, I think, was really spurred by the number of people who either tweeted, texted, or emailed about one particular story. Gary, can you guess what that story was?
I don't need to guess. I know exactly which story it was, but I'm going to correct you a little bit. This was not spurred by the number of people who texted us sensational headlines. This was spurred by you getting into the nitty-gritty of the case and sending me something that was actually interesting. I have so little interest in this Geico case where some woman got a SCD in her car, and, you know, it's every headline right now, and everyone's tweeting it to us, and I get it, but you know, the take that most articles have been giving, I don't care about because I've seen it in 7, 8, 9 articles. But Mark dug in and he sent me a little tidbit that I decided, yes, I'm very interested in talking about that.
Right. So if you haven't been following this and you've been under a rock somewhere, there was a arbitrator's award that was confirmed by an appellate court, I believe in Missouri. And the award was $5.2 million against Geico, who was the auto insurer for a woman who claimed she got HPV by having unprotected sex in the car. And that makes a great headline, right? It
makes an amazing headline. And before we go any further, let's just put it on the table. Geico's a friend of the show. We love Geico. Excellent company. You know, bundle and save. They're great. But, you know, you hit the news, you got to be talked about. I don't know what to tell you there, Geico.
Well, and I think that's an important disclaimer as well, because when I read the opinion, it became a lot more nuanced than what it was.
Yes.
At least as initially reported, it appeared to be that some arbitrator and some court had just gotten it wrong. Well, what actually happened, if you read the opinion, which is, Gary, 15 pages by the Court of Appeal?
It might even be 18. Yeah, it's long.
This is what happened. The woman made a claim she had a characterized by the court, at least, a long-term romantic relationship with the owner of the car. Mm-hmm. So this was not a wham, bam, thank you, ma'am, or bing, bang, bong. Well, it might have been a bing, bang, bong, but it was clearly as a result of a relationship, apparently, if you believe the facts of this case. She then claims to have gotten HPV, which is interesting. And one of the things they said in the opinion was that the gentleman who apparently had HPV had a tumor in his throat. And they linked that to apparently, remember that story years ago about somebody else who had throat cancer? I think it was Michael Douglas.
And Catherine Zeta-Jones.
Apparently certain sex acts, up close and personal, can get you HPV in your throat and cause cancer. And apparently that's what happened to this guy. He apparently had notice of this, apparently did not. And I'm going to keep saying apparently because I don't like allegedly.
Sure.
Apparently did not tell her they had unprotected sex, but it did not appear that it was throat action. It appeared it was some other, either anal or genital, because it was tough to know because they did not distinguish in the opinion. However, she contracts it. She tenders the complaint, meaning she's got a lawyer. The lawyer basically makes a complaint against the insurance company. The insurance company tells them, Geico tells them, go pound sand. And here is where it gets a little tricky. And if Geico's got a lawyer, we'd love to talk to them about it. I'm sure they do. Geico says we're not going to defend the driver, gentleman who had the throat cancer, the tumor, and we're going to go to federal court and do what's called a declaratory relief action, which means they're going to file an action and say, Your Honor, make a decision here as to whether we have to defend. Here's where it got interesting. The lawyers, because there was no defense tendered by Geico, there's apparently a statute in Missouri which says basically if your insurance company has failed to or says they're not going to defend you, you can then enter into an arbitration and limit your damages to the amount of the policy. Gary, do you have the language?
Yes, I do. To the extent that Geico claims it should have been able to litigate any of the purported findings of fact and conclusions of the law in the arbitration award, we would note that it had every opportunity to enter defense of its insured without reservation and thus to litigate such matters, but chose not to do so. Geico did not take advantage of this opportunity, instead denied coverage and refused to defend the insured. Moreover, Geico initiated a declaratory judgment in a federal court seeking a determination as to the obligations under the insurance policy, and that federal action provides yet another forum in which Geico may defend its interest. See Brit 57. Yeah, there you go. That's the end of it, I think.
Right. So basically, there's a couple of questions here, obviously, that come to mind. Number one, by the way, whoever the plaintiff's lawyer is for, what are her initials? MO?
Yes, I believe so.
Kudos to you for some clever lawyering, because it looks like this person, somebody recognized or had this statute. They knew that the statute said if the insurance company doesn't tender a defense or doesn't provide a defense, that you can then enter this alternate universe of arbitration, which is what they did. The arbitrator apparently was
sympathetic.
Very, very good, Gary. Thank you. Yeah, that's arbitrator was very sympathetic and ended up hitting the insurance company, who wasn't actually present, for $5.2 million. Interesting to see whether the federal court takes some action here. But there's a lot of nuances here. Number one, the insurance company, Geico, has made the argument, I believe, and will continue to make the argument, that this was a setup by the people who were in a relationship, a romantic relationship. I don't know that it details how long they were in it, but it was clear that there was no dispute that they were in a relationship. I wonder if the relationship was during the time that the person, the insured, namely the car owner or driver or car insured, had this throat issue, and whether she knew or didn't know. And I'm sure that's one of the things that Geico is saying. But it's apparent to me that the arbitrator felt at a certain point like, well, you're not going to come in here and you're not going to defend your insured, then you're going to pay a price. The trial court had there appeared, at least if you're reading between the lines of the appellate opinion, appears to have also similarly been somewhat peaked at what ended up happening. But it'll be interesting to see later on if and when the federal court acts, because that's basically what the state court has said. The state court has said, okay, you want to raise all these issues. You didn't tender a defense, so therefore don't complain now that you couldn't, and go over to federal court and wait for that. I really wish the Geico lawyers would come on and we could get into the weeds on this, because it's amazing and reminds me to some degree of kind of the McDonald's verdict that you used to hear about, and people used to claim that was an example of the court's gone wild. And this one has the same feel about it. And I'd love to know some of the facts of it. When I sent that quote out of the opinion to Gary, didn't it kind of make you whiplash a little bit, Gary, that certainly was not being reported accurately?
Absolutely not. And like I said earlier, it was the first thing that got me interested in this case. I had obviously been sent the link, countless times, but this take actually is something of interest to me, and I will keep an eye out for it. I would welcome both lawyers from either side on if they want to come. I mean, obviously we have a relationship with Geico, so they know how to get to us, but it's not hard to find us on Twitter. If you're on the other side, we would welcome both of them. I mean, Mark, you long ago told me about a line from a movie we both love called The Martian, where Matt Damon is stranded on Mars and he declares that he's going to have to science the shit out of this in order to survive. And you recalled or recounted that you told your son when watching that movie that you were going to have to lawyer the shit out of it. That was how I felt when I saw your more detailed take on this, that the lawyers on the plaintiff's side lawyered the shit out of this. And yeah, they got a sympathetic arbitrator, but it'll be very interesting to see how this proceeds.
Yeah, I agree. I agree. And then before we go, there's one other case that I thought was interesting that somebody had actually tweeted at us. So we listen to your tweets, and it was a friend of mine. I've talked to him for a while. Dave Chestnut has got this case involving a Las Vegas Raider.
But just to be clear, yeah, Henry Ruggs. I think everyone, who listens to this show might be familiar with this story or might remember us talking about it. He was arrested after driving apparently intoxicated away from Topgolf in Las Vegas, and he was in, I believe, a fairly souped-up Corvette, and he was doing 150 plus when he slammed into an innocent person's RAV4, killing the driver and their animal, which the animal thing is reported every single time this story is talked about, which is a little unusual, but now there has been a development. You want to tell us about it?
Right. They filed, apparently, when they got discovery. In most criminal cases, the prosecution is obligated to turn over discovery, police reports, body cams, things like that. There was apparently a tape recording of one of the officers on the scene, apparently again, maybe we'll call that the beyond apparently a reasonable doubt. The colloquy went something along the lines of, "Hey, Sergeant, I don't have any signs of intoxication here."
Right. No signs of impairment. So how am I supposed to go about a sobriety test?
To which the sergeant responds,
quote, "Driving behavior and death alone is going to get you a warrant all day."
Which is, by the way, reminded me instantly. A lot of things remind me of my father, but my father used to say, "A dead body and 2 kilos of coke is an awful lot of probable cause." That was one of his favorite lines.
Sure.
Here you didn't have the 2 kilos of coke, but you've got, I'm not joking about it, but you've got a dead body, and as the sergeant said, that generally get you probable cause. What the argument is here is to suppress the blood results, meaning throw them out, because they're going to say there was no probable cause, because here you have the officer on the scene who's admitting that they had no indicia or signs or evidence of intoxication. So the fact that somebody is now going to have their blood drawn without probable cause is going to be an issue. The cynic in me would say most judges are going to err on the side of saying you're driving 156, dead body, dead animal. I'm not going to throw out your blood result. But it is an argument, and it is a legal argument that will be litigated.
And we'll be watching for it. There's also some other news out of the world of the NFL that we're not going to cover on this episode, but we may invite our friend Jimmy on, mostly just out of sadomasochism. The Chargers are having infighting with their ownership, and because I just can't help taking a beating, I guess we got to talk about it. So,
well, you should, because this has given the fact that the Broncos just entered into a sale for just below $5 billion, four and a half and change.
Yeah.
It strikes me, and we'll talk to Jimmy about this, but it strikes me as that we're headed towards a $5 billion actual sale. I mean, there's been valuations at $5 billion, but this would be the first time, if the Chargers sell, that we've eclipsed or exceeded the $5 billion mark.
Well, having seen the Broncos Stadium and having seen SoFi, I believe that they are probably worth north of 5, and nothing would make me happier as a Chargers fan to see the Spanos get the hell out of the way. And, if you're in need of some Broncos gear, I bet you're going to be able to find it at Walmart sometime soon. So thank you guys so much for listening. Mark, thank you for your time on a Sunday, and look forward to those stories and many more this coming week. And I believe, Mark, I'll see you this coming Saturday at the Corolla Drinks Barbecue, yes?
Oh, yeah. And it's, my understanding, sold out.
Oh, yeah. Sold out. The whiskey tasting with you guys and cigar thing is sold out. I mean, it's a star-studded affair for our hardest core fans, and we look forward to seeing everyone there.
So maybe we should put up two tickets to Scalp, and then give the proceeds to one of our favorite charities or something. What do you think?
I think that sounds good to me. You get with Lynette and we'll figure it out. And I was thinking, just to keep the continuity with last year, maybe we'll do a Beyond a Reasonable Doubt during the whiskey tasting.
I think we have to with the three of us. It's too bad I didn't think of it. And we can talk about it on the show this week. What is the big show this week?
Big show's going to be Friday, and we're going to drop it right away so that we can record a Beyond on Saturday and drop that right away. So probably Tuesday, okay. Friday, Saturday this week is our schedule.
So we'll tease a Jimmy Kimmel, Adam Carolla, Dr. Drew, and myself event that we had last week. So
There you go. All right, Mark, thank you again. You have a great day, and thanks for your time again on a Sunday.
See ya.
All right, bye-bye.
Thanks for listening to Beyond a Reasonable Doubt. Stay tuned for more bonus episodes coming soon.